Manny, as you've said to us previously on this program, the people who are charged with the most serious crimes have the most to lose if we get it wrong. What's the situation with the courts grinding to a halt due to the virus?
Well, it's quite problematic, Scott, due to the current environment, because usually, not always, but usually people charged with serious offences are refused bail and held in custody awaiting their trial or sentence, as the case may be. And I'll talk to you separately about those charged with serious offences who are out on bail. But those that are in custody awaiting bail, if they are serious offences prior to the coronavirus issues, it could take somewhere between 18 months to 2 years to get to trial. Now, with the situation, it is very unpredictable, and I don't think anyone would have any statistics they could give you to tell you precisely how long it will be for those now in custody that have just been charged to get to trial if they are defending the charges. However, it is not at all unrealistic to say that it could be 3 to 4 years that they'll be in custody. And that's an extraordinary amount of time about which around the world human rights organisations would have a lot to say.
What about the percentage of those people who may be found innocent? Is there a percentage of those people who, in your opinion, will be found innocent?
The innocent rate varies substantially depending upon the charge and the nature of the charge. But it's not uncommon if you were to apply just a very broad rule, and you said just conservatively, and in my view, this would be conservative, that 1/3 of people would be found innocent, if not more. When you consider the many thousands of people that come before the court, that is a very significant number. If there's 5,000 people coming before the court, you're talking about 1,500 people that would be remaining in custody for a period of years and then subsequently be found to be innocent.
Manny, could some of the sentences, if they're found guilty, could be less than the time they've spent in remand?
Yes, absolutely, because often one doesn't know until the matter's progressed a significant way as to the extent of not only the case against an accused person, but as to the extent of the nature of the allegations. So in other words, initial allegations may be much more serious than when they end up in the courtroom for a variety of reasons. A witness may recant his or her statement, making things very different. So at the beginning, you have the allegations that are made by police based on what they understand to be the anticipated evidence, but that often is not how it pans out. And so ultimately, when that person comes on for trial or sentence, if that person was to change their plea, the actual seriousness of the allegations are quite different to how they started. Additionally, it is common for there to be a plea bargaining process in our system. So although someone may be charged with a very serious offence, just for example, break and enter and robbery in company, that may change to be a lesser charge of break and enter and robbery with no company, for example. Now, they are very significant culpability in relation to an accused and would reflect very significantly on what the sentence would ultimately be. So, yes, someone who's been in custody, whether it's anywhere between 2 to 4 years, that would be the non-parole period that would be relevant to any sentence that would ultimately attach. And it could well exceed, the ultimate sentence could well exceed the period actually spent in prison.
Do you have clients who've already been in prison for a long time on charges similar to these, so who could theoretically spend more time in jail before having their day in court to prove whether they're innocent or guilty?
Yes, I do, and indeed one of them who was charged with very serious offences, who had been in custody for a period approaching 3 years for a whole variety of reasons, was ultimately late last year granted bail in the Supreme Court because of the delay. Now, this is all pre-coronavirus, obviously, because I'm talking last year. But that person, for example, was granted bail. One of the reasons the person was granted bail is the serious concern that even if he was to be found guilty of the charges and the nature of the charges as they presented themselves 3 years after he was charged, he might end up having served more time than what he would be sentenced to if he was found guilty after trial. So there won't be too many examples of persons, the effect it will have on persons as a result of the coronavirus issues. However, what I can tell you is this. The Supreme Court, both in New South Wales and Victoria, in very recent cases, that is cases since the coronavirus, have made it clear that in determining whether to grant bail or not grant bail for such serious offences, the coronavirus issue, the potential for an accused person to catch the virus or for it to be spread within the prison system, is a very now real matter to take into account. So it may well be and pan out that persons who would prior coronavirus be kept in custody will now be given bail. Human rights conventions say something like a period of about a year should be it. So we are talking about people that have been in custody for years, and it will get worse.
Manny Conditsis, thanks for bringing this aspect of the law to our attention.
Thank you, Scott.